Thank you for returning from the lunch break for our afternoon session. Just conscious of the time, so I'd like to kick off as soon as possible. And also welcome back to everyone who's tuning in online. Hope you've been enjoying the day so far. Just to bring to your attention, we've got a brilliant panel coming up next, hosted by Gatehouse Law. And I'm going to hand over to Paul Reed, QC, to moderate on business interruption claims and the pandemic. Thank you very much.
Good afternoon, everyone. Welcome to the graveyard slot after lunch. We're going to do our best to at least try and keep you awake. A few words about myself. Thank you for the introduction. I specialise in insurance and construction, engineering, oil and gas arbitrations around the world, but business interruption as a result of COVID has become a major part of my practice, and we've learned a lot from it. I can tell you what I'm not going to speak about. I'm not going to tell you how I wear my slippers when doing an online arbitration. How over lunch I go out to my allotment just to have a look, rather than preparing for the afternoon, and all the interruptions I have where the door quietly opens and then shuts and people wonder what's come in because they can't see what's opening the door. What we're going to talk about is what we've learned as a result of business interruption claims, the claims that are going on, how the arbitrations are taking place, and some of the problems. We're lucky today to have two people to discuss it. Amanda to my right, and she's a partner and head of dispute resolution at Hamlins, and she's done a lot of work advising a whole raft of organisations, companies, partnerships and high net worth individuals who've had to face the fallout relation to COVID and business interruption losses and claims and how to resolve those, as well as professional negligence and so forth. Dan, to my left, is a partner in Winter Hill, and they're a firm which specialises in representing policyholders. And he has been consistently recommended in this area of law for a number of years and specialises both in business interruption but also construction risks, professional indemnity and so forth. And I think during this lockdown, he's probably like others, his feet haven't touched the ground. And so what I'd start, I think, by asking the two of you some questions, starting with you, Amanda, to ask you what sort of problems have you been seeing in the infrastructure projects, construction world dealing with business interruption and COVID?
Okay, thanks, Paul. So while lockdowns per se haven't been that lengthy for the infrastructure sort of sector, so for example, in the UK and in Australia, the governments have made efforts actually to keep the sites up and running, albeit with certain restrictions. The sector usually operates with a relatively low profit margin and needs significant material and labour resources for the works to be progressed. The lockdowns and restrictions worldwide have impacted labour movements and supply chains, as have the increased requirements for health and safety measures, such as the number of people you can have on site and, the social distancing. And this has led to delays and to projects and some excessive costs and overspends and many disputes about who actually picks up the bill when you're in that sort of situation. The result seems to be that there's an inconsistent approach. In some cases, you find that people are actually sort of trying to work together in a project to move forward, not to get locked in a big fight. But for others, unfortunately, it's been a case of actually getting locked into disputes.
So what sort of disputes have we been seeing?
So we've seen some disputes that relate to sort of force majeure clauses. As people will be aware, that really applies to events that weren't reasonably in the contemplation of the parties at the time that they entered into the contract itself. And the party that's relying on that provision has to show that it was beyond their reasonable control to try and sort that out. So while each case needs to be looked at on its facts, it's clear that, for example, in the case of JCT contracts, there is some provision for force majeure clauses. The query is force majeure, is COVID-19 and what's happened with the pandemic actually something that counts as force majeure? Those sorts of disputes are actually being dealt with right now. And even if it does count as actually force majeure, in the case of JCT, it wouldn't be something that would allow an extension, it would allow potentially an extension of time to the project for the contractor, but not necessarily the costs and loss and expense. There's also the further costs, of course, of delays that the employer's picking up in these sort of infrastructure projects, dealing with extra costs, interest payments, and loss of income, for example. There are obviously other types of contracts, and this is a massive generalisation, but those sorts of disputes are being seen not only in infrastructure projects, you see them in supply contracts and also in manufacturing as well. But also, frustration has been a real focus. So where, for example, there are no force majeure clauses, the construction engineering sectors, infrastructure sectors are all thinking about, can the outbreak of COVID-19 and the pandemic and the impact be such that it's a frustrating event? And they're raising these sorts of issues in arbitrations, and I know there are various ongoing at the moment, to try and work out if that's a way potentially to get out of what are quite onerous obligations. And for example, if you look back at what is frustration, the court was very clear about how it should be deemed. And it's really where, without fault of either party, the contractual obligation has been something that they're unable to perform because the circumstances in which they do that would render it radically different from the actual contract that they'd entered into in the first place. What the courts were looking at is really the expectations of the parties at the time. So the bar for proving frustration is really, really high. And we've seen common law sort out certain issues about whether, for example, just extra costs are enough, whether actually it's impractical or onerous, is that enough? And the courts have held that it's not. So even a radical change in the economic factors, such that the project's no longer commercially viable, that might not be enough for frustration, and it probably isn't. So, and also, just looking at delays, for example, if there are transient delays, that won't be sufficient. So thinking about it from the infrastructure side of things again, because there was no real blanket sort of prevention of going back on site for any real long period of time, it's difficult to raise those points. And what we're seeing is arguments such as supervening illegality being raised. So, for example, suggestions that because the law has changed and the restrictions have changed, it's no longer possible to carry out those sorts of contracts. And that would involve sort of, because to do so, you'll be infringing those requirements, essentially. And so that seems to be a potentially very good argument for hospitality, for industries like that, events, etc. But difficult again for the infrastructure kind of industry, where in actual fact, no blanket ban was actually introduced in terms of many months, for example, not being on site. And the government stopped short of that and actually instead allowed works to carry on, but obviously with restrictions. So we're aware, though, that lots of arbitrations taking place to deal with things such as frustrations and seeing whether a contract's frustrated or not. Problem with that is it leads to inconsistent decisions potentially. Also, it doesn't really resolve it for everybody else. So we're obviously left with a scenario where we haven't got a precedent that actually will help things move forward. I just wanted to mention quickly as well, if I may, delay in startup cover, because that's really business interruption cover, which we'll be talking about a bit more, for the construction industry, where there's been a delay to the actual completion of the project. What we're seeing there is that there's not much cover there, because the cover that was in existence, generally speaking, related to physical damage. So there had to be physical damage to the works. There are, or at least there used to be, some non-damage extensions for delay in startup cover. So that's something that could also be potentially useful. But what we're finding, unfortunately, is that because there's not that much insurance-backed support in this scenario, you're dealing with people who unfortunately have to try and resolve this some way, one way or the other. And some, as I say, are and some aren't. Yeah,
so having regard to that, how do we think we're going to move on from those issues? Because all the industries are now started getting going again.
Good question. I think the difficulty with that is at the moment we're a bit stuck in that scenario where some projects have luckily got people who are prepared, or companies who are prepared to try and make a resolution together and move forward and perhaps split and allocate the risk in what seems to be a fair way. There are some scenarios where, for example, wordings are being changed very quickly in a quick knee-jerk reaction to what's happening because of the pandemic. But that doesn't really solve things properly, and it leaves for uncertainty. It's very difficult to see how things will be resolved. to avoid, for example, scenarios like ongoing disputes, lots of arbitrations continuing, or at least parties being sensible about it. And even then, it seems to me, it seems a bit unfair. So I suppose the situation's got to that either we carry on in this very difficult scenario with people not knowing where they go, or potentially a lot of people in the infrastructure industry actually going under because they just can't cope with these extra costs? Or is it now the time for the government to step in? And that's the sort of query, I suppose. Because the reality is, while understandably, the government decided to introduce these measures for health and safety and to curb the pandemic, the reality is that it's because of those measures that the industry is finding that they have to pick up a lot of extra costs. So,
thank you for that, Amanda. So, Dan, what issues, big issues, remain outstanding in COVID or COVID-related business interruption disputes?
Well, how long have you got, I think, is the answer to that. I mean, we had the FCA test case in the UK that was designed to bring about certainty in the market. And, you know, one of the ironies of that is that we have almost an unlimited number of unknowns still to be determined either by arbitration or through the court system. But to answer your question, we have many factual patterns that are going to need to be thought about, assessed, determined in relation to the application of the Supreme Court's declarations. That's one category. But the big money issues, relate to aggregation. So, you know, if you have a number of losses, to what extent are they connected? To what extent we have multiple limits under a policy, that type of thing. We have the other big money issue out there at the moment is the potential appeal of the High Court's assessment of prevention of access wordings that were found not to respond at the High Court level, but most commentators, perhaps I would say, are inconsistent with the Supreme Court's analysis around concurrent proximate cause. So there are six cases currently working their way through the commercial court. Prevention of access are including a couple of those, but other big money issues relate to quantum. We have, you know, how do you treat furlough payments in the calculation of BI under the policy? That's a big question. We don't have any authority on that at the moment. And then if you're a sort of commercial landlord that had a BI policy and you have a sort of definition of loss around loss of profit, there are big money issues at play there for owners of shopping centres and things like that, or big commercial landlords that are going to need some case law and going to need to be determined.
Now, these issues, aren't they, are being played out also in arbitration. And should we be concerned by the lack of legal precedent arising from the arbitration process in the market?
Shall I go first?
Yeah, Dan.
Well, if you're a policyholder, I mean, from a policyholder perspective, and you know, you either run an arbitration or you want to run an arbitration and you think you're going to win or you might have won, you know, I don't think you care too much about the niceties of the law or the wider public policy points. But from a sort of legal perspective, from a wider public policy point, or from a London market perspective, my personal view is that it is a concern that we have very little case law other than the FCA test case decisions themselves. And that's a problem, if you think about it, for the London market, because the London market wants to resolve all insurance claims as soon as possible. It's also a problem for, you know, English law that's being applied around in different jurisdictions. You know, English law is exported all around the world, and you know, we want that to carry on, and we want some case law authority coming from the commercial courts in London to do that. So there are issues. The reason why there are issues for me about arbitration, there's a sort of theme going on in the market, a trend at the market. In the market at the moment, where insurers are on a scheme-by-scheme basis. This is my experience. There may be other stories. Amanda may have a different view, but insurers are seeking to run private arbitrations without an appeal process, final and binding, either on a group of policyholders or an individual test case, with no right of appeal under Section 69 of the Arbitration Act, and that's a problem. because you can't appeal it. And the reason why they're doing that, they've got the whip hand at the moment. I think they're concerned about litigation. Insurers are concerned about hundreds, if not thousands, of people making complaints either at the Ombudsman or launching tactical arbitrations and the cost that generates. And what I'm seeing is insurers and their legal teams coming to policyholders and their legal teams and proposing to pay for the claimant's legal costs for running the arbitration. But the quid pro quo of that is that you give up certain rights in the process. So there's the health warning right there. And then, of course, you know, arbitrations aren't binding on any other insurer. It doesn't create legal precedent. And we only need to look at Lord Mance's recent rationale in deciding 183 hospitality policyholders' claims against China Taiping, you know, for me, which is a sort of paradigm example of both the virtues of arbitration, you know, getting it up and running and decided in 4 months, you know, that's pretty quick on paper only, really. You know, that's a good outcome. Versus not having, it actually didn't go the way of the policyholders and they had no right of appeal. So it's a paradigm example for me of the problems.
Yeah. Amanda.
Yeah, I was just going to say, I do agree with Dan on this, actually. I think there's a lot of problems as a consequence of a lot of arbitration, and that's really obviously the lack of precedent in this sort of area. I mean, even if you just think about, for example, as you say, furlough and the government support, the way the ABI has been approaching this, the Association of British Insurers, has been to say, well, actually, why should the insured be able to actually claim for those monies as well, because they'll be double compensated? And the government has been responding to say, well, of course you should, because that's something that was contractually liable for, but also it's not right for taxpayers to be picking up, you know, that particular scenario for insurers and letting them off the hook and things like that. Some principles would be very, you know, helpful to be seen in a kind of court context so that we could get some clarity and so we don't end up with lots and lots of arbitrations with inconsistent decisions.
Yeah, and of course, a lot of these people, businesses, have primary insurance cover, excess insurance covers, and various layers, all with separate arbitration clauses. And so what they're forced to do is have multiple arbitrations in respect of the same subject matter with the risk of inconsistent decisions. So really that brings me on to the question, Dan, what realistic solutions might the insurance market or lawyers have to these problems, both in the short term and perhaps in the medium term?
Well, I mean, I think the short answer is there aren't that many solutions in the short term. I think that we're in the gift of insurers at the moment. If they've got the whip hand in the negotiations, well, it's for insurers to put forward alternative terms. You know, or I guess it's for policyholders and policyholder lawyers to be brave, either exercise their right to litigate, if there is a right to litigate, and that's a big if in their policy wording. There aren't that many sort of short-term solutions. Maybe FCA intervention on the subject. I don't think there's any sort of appetite from that. I haven't seen any signs of that personally. Otherwise, you're looking at sort of medium-term options.
They were considering doing further issues, but I don't think they've made any announcements yet. So it really does raise questions both for the insureds in relation to arbitration, but also insurers, because one has a certain amount of sympathy for them, because I know maybe not many people do, but they wrote these policies in a time when, had you suggested there might be COVID or something similar happening, they would have thought you were mad. So they charge very low premiums for very substantial risks, and now they're faced with not dozens of claims, not even hundreds of claims, but thousands and thousands of claims, all with separate arbitration clauses. So in a sense, the real question is, we move on now to group claims, and what we think about group claims moving forwards in terms of the residual BI related issues. I mean, having regard to the fact that we've just said there's no precedent and they've each got a separate arbitration clause.
Yeah, I just wanted to come back on your point about, underwriting intent. I mean, we saw through the pandemic, the very first sort of message that was sent out by insurers on the happening of the pandemic was that the subjective intent of the underwriter was never to cover pandemic risks. But of course, subjective intent is irrelevant, so I've got very little sympathy, I can say that as a policyholder lawyer, don't worry, with that position. But, in terms of group actions, I mean, look, there's still tons of problems out there, scheme by scheme, stacking up. We've got reinsurance issues also stacking up behind that. We've got residual litigation problems probably relating to other financial intermediaries connected with that, all of this. I'm surprised not to have seen more group claims, I think is my sort of one of my observations. I think it will be difficult to run group actions around aggregation on different types of wordings just because of the complexities of that. I would expect to see group actions on a scheme-by-scheme basis. Of course, we had the Hiscox Action Group and the Nighttime Industries Association that was sort of quite politically driven and got the desired outcome. But I think, just to marry the issues, one of the reasons maybe why we're not seeing those group actions and why we've only got 6 cases in the current sort of commercial court may well be this trend that I'm sort of alluding to, that actually behind the scenes there's a lot of arbitration going on and insurers are coming, because of the risks, because of the concern about group actions, that insurers are taking the initiative, coming to policyholders, or more importantly coming to brokers to facilitate those sorts of ad hoc processes.
Amanda?
Yeah, I suppose I agree with that. I think I suppose one of the difficulties is trying to persuade insurers to move forward and to go for group actions and agree to take things forward on that basis as well. And what's the incentive? And I think perhaps just being faced with a whole range of different types of other claims, constant arbitrations, several separate arbitrations, false complaints and things like that might be a method to sort of try and see that go forward. But I do also agree with what you said, Dan. I think aggregation itself is a really difficult topic because it's so much dependent on the wording. I think it's going to be very hard to have that dealt with by a group action. And they're also different. I mean, I must have looked at hundreds of wordings over the last 18 months, specifically relating to BI, and the wordings in relation to aggregation on BI policies, I mean, they're a mess, frankly. I don't know who put them together, but that is, there's not uniformity, so it's not as if there's a generic wording out there around originating cause or something like that that the court can determine, and that there's going to be a sort of fix for the entire market. There's not. There's too many different variations out there.
So I think my final comment on this, there's an awful lot of wait and see from businesses. So they know there's multiple claims going through the commercial court. They really don't know whether it's the same wording that they have or not, but they're all reluctant at the moment to proceed with their own arbitrations. But I would expect in the next 6 months to see large numbers of arbitrations commenced, which really leads me on to ask the question, what are the advantages, disadvantages of arbitrating these type of claims?
Shall I go first?
Yeah.
Well, I mean, everyone in the room appreciates the inherent flexibility of arbitration versus litigation. That's the first thing to say. But, from a policyholder perspective, look, like I said before, that they don't really care about the niceties of the law or the wider common point. They want it resolved quickly, cheaply, cost-effectively. And arbitration, especially an ad hoc arbitration, either on an area, on a fast-track procedural set of rules or on a bespoke, arbitration agreement, where the issues can be determined on paper, for example, before Lord Mance, as in the China tapping case, are a great example of how you use arbitration, and the benefits really are the perceived. I use the word perceived because it's not always the case. Cost benefits, speed benefits, certainty benefits. But the
Yeah, well, I was going to pick you up on that because I think it's true that there are lots of perceived benefits, as you say. I think I've personally come across scenarios where arbitration has become incredibly expensive because we've had 3 arbitrators on a panel. And then, of course, if your seat is overseas and also paying for arbitration rooms, it can quite quickly rack up. But, of course, that depends on the scenario, and it's not always, it's just something to bear in mind that I'm not sure it's always a cheaper option, even though, as you say, it's perceived that it is. And I suppose that's the other thing to think about, is you're saying about flexibility, and I think that's right, there is flexibility, and that's great, as long as you've got a sensible opponent you're dealing with, because if you get the wrong sort of opponent, you end up sort of, things get dragged back and you don't really have the same deadline and pressure in the same way as normal court.
Well, I mean, just coming back, one of the sort of things that I'm seeing at the moment, there's sort of anecdotally, is that there's more goodwill now within insurers' legal teams than there's ever been, compared to sort of conventional policy coverage disputes where, the lines are drawn, the battle lines are drawn, and
different world.
Nothing is nothing is agreed. You can't agree whether it's night or day, etc. It's a very different world at the moment.
Yeah, true.
I mean, I would simply make this observation, that these business interruption claims are ideal for arbitration in one sense, because they're interpreting one contract, a policy, normally running to no more than 10, 20 pages. And once you've got a decision in principle, quite often the insurers will go away and then seek to agree what the quantum is of the claim. And that can all be done in a space of, and this is genuinely rather than the hypothetical benefit of arbitration, I've seen it done in 2 or 3 months, because there's a will to get it done, and there's certain motivations within the insurance industry to do that.
And many at the moment, you don't, I mean, just to dovetail that, I mean, many don't require expert evidence. In fact, none usually on rules when you're interpreting contracts. Very few require witness evidence at the moment. And what you would normally seek to do is have liability determined first, and then quantum, if you're successful, quantum adjusted in the usual way after the event.
Yeah, so with that in mind, what do you think ought to be thought about when you're contemplating doing an arbitration for a business interruption dispute?
Shall I go first?
You go.
I mean, look. I mean, day one. Do you have the right to arbitrate in the policy? If so, what arbitration rules are there? Sort of is the starting point, obviously, and I sort of touched on this before, that I reviewed dozens and dozens of policy wordings, and I think 70% of the dispute resolution mechanisms in those policies were arbitration. And I think of those arbitration clauses, most of them were LCIA or RES rules, not fast track, just standard LCA and RES rules. But for me, I'd be thinking about, who the arbitrator is, whether there's any potential issues of perceived bias. Maybe you're going to think carefully about who your arbitrator is and who have they historically been acting for. Potentially, who were they advising last week? Maybe. Going to be thinking about, the extent to which you're prepared to waive privilege or confidentiality. Think about knock-on effect maybe on third-party claims that may be out there in relation to brokers. We haven't touched on that yet. The extent to which you're going to be able to use that award, to either help you or defend it or whatever. I mean, there's all sorts of commercials. I mean, there's no one right answer, right? It depends on what your policyholders' needs are at the start of the process, with a merits assessment wrapped in all of that.
Yeah, I mean, I agree with that. I also think that there can be, where there are towers of insurers sitting behind, where you've got different excess layers and reinsurers, they can sometimes be subject to completely different arbitration clauses and completely different sort of forums sometimes even. So that adds an extra layer of complication as well to the situation.
So that begs a question, which is the counterpoint. Why use the court process then?
Well, I mean, I think for a lot of people and a lot of coverage lawyers right now, you only need to mention the words pre-action protocol, cost budgeting, pilot schemes of disclosure, for people to, cringe at the thought of it. And I think the honest answer is that the courts are probably the dispute resolution choice of last resort at the moment. Well, why would you, if you could opt for arbitration and resolve the, quite technical issues on paper in 3, 4, 5, 6 months time? I mean, I'm struggling to see the benefits of it personally, but maybe, someone else has a different view.
Well, I think it's right what you say about some of the obligations for court, in particular, if the disclosure pilot scheme and the DRD document and that we've all had to struggle through, and also just the fact there's a lot of front loading quite early on now in terms of costs in the court. I suppose the only angle, and maybe this isn't relevant anymore because of the FCA decision, is just the fact that there's the publicity, there's the fact that, you know, if an insurer has behaved in a certain way, perhaps they don't want that to be exposed, they don't want that to get out there, and they don't want to set precedents. And as I say, perhaps the latter isn't such an issue, but I suppose that's the only kind of benefit in the right sort of case, perhaps with the right sort of difficult recalcitrant insurer, perhaps.
So having discussed it so far in the UK perspective, what are we seeing playing out in the other jurisdictions?
Well, so in the US, as I understand it, there's obviously a lot of arbitrations that we just don't know anything about at all. But there are obviously also a lot of court actions, and in all the various different states. I had a sort of very brief, by no means an expert, look at some of the different issues that are happening in New Jersey, in New York, and in Pennsylvania. And there seems to be a very common theme, a thread throughout all of this, and it seems to be that, for example, in New Jersey, out of 55 cases, only 2 were seen to be coverage. And I think the reason for that is there seems to be a very different policy wording. So what we're finding is that there are often exclusions that specifically talk about viruses or about pandemics, and secondly, there is a need for physical damage. Where those couple of cases, for example, are succeeding is because either the exclusion doesn't exist, it seems, and as I say, massive generalisation, but just to get a feel, or that in fact that they were limited in some respect. And I suppose the other thing to say is that with those cases as well, and the courts are very keen that this came across, there was coronavirus present on the premises, which brings into debate a whole other issue about damage, but we've got time for that today. But anyway, yeah, that's in the US, I think. So very different, really.
Well, what I find particularly interesting is that you've got some standard London market wording, which is being tested both in courts and in arbitration in different jurisdictions, which have different rules of interpretation. And so what is, you know, from a purely lawyer's perspective, it's interesting to see how a civil code interprets it, say in the UAE, how it's interpreted in Canada and in America, and the Insurance Act in New Zealand, and they're all coming up with different views about whether you interpret it, say, on the basis of what the cover they should have, on the basis of an Insurance Act which is pro-insured, or whether it's the objective meaning of the words. And what you tend to find is that there's reference every time to the FCA decision, and then, I don't know how to put that, that's the point of departure. Yeah, they refer to it and say it's a erudite, worthy exposition of the law, and then say, put it to one side, as I've had experience, and say, but we're going to do our own thing. And I've had experience of some of these arbitrations, most recently, believe it or not, in Peru. And I'm off to South Korea shortly to do an arbitration. And it's quite interesting to see how these different tribunals take a sideways look at some of what we consider to be extremely intelligent and clever reasoning by the Supreme Court. Dan, I don't know whether you've got any thoughts.
I mean, I have to confess, I'm obviously aware of some of the international decisions. I haven't pored over them, for the reasons that you've just said, that, different rules of legal construction are in play. I mean, the only observation that I'd make, and I think there was a very unhelpful regulatory decision in Australia last week. Was it on Friday? It came out. The regulator had intervened. I think it was on sort of prevention of access type issues following government lockdown. I understand it went sort of in the insurer.
Yes, it was helpful for insurers.
Yeah. So I'm probably going to hear about it in the next month or so. But my point is this: is that the government responses in each individual country was very different to the UK. So you can't extrapolate necessarily, the action and the response of policy wordings from one jurisdiction to another.
So that begs the question, where a number of these international PLCs and companies have master policies for cover in different countries. how they're likely to be interpreted, because one can see how upset somebody might be as a PLC with different arbitration clauses in the subsidiary wordings, which are all interpreted differently with different levels of power in different countries.
Yeah, and I mean it is an issue actually, and I mean if you think about it, I mean a lot of the way these policies operate, they're in effect a top-up policy for the local jurisdiction, either because it doesn't respond or because it's exhausted. So if you have if you're a PLC with retail shops in 17 countries around the world, one of which is the US, legally you are permitted to roll that into your London program if the local policy doesn't respond or is B, exhausted. And there isn't any law on that at the moment.
No, so moving on, I think that's about all we can say we've learned from the cases so far, is that they're all going to be treated differently in different jurisdictions, even with the same wording, which is perhaps unhelpful. Turning back to the FCA case, though, are we seeing any related litigation on the back of that?
Shall I go first? Yeah. I mean, there's a couple of areas. I mean, I mentioned litigation against intermediaries. I mean, brokers have been helping place and advise upon these wordings. It's their primary duty to the policyholders. So I know for the last 18 months, there's been a lot of concern in the broker space about, a wave of E&O claims against brokers is one area. And then on the back of that, I think there's been significant notifications under PI policies and inverted commas block notifications to PI policies. So if claims do materialise, and they haven't actually materialised yet, certainly in relation to sort of the placement of the policies by brokers, but there could well be secondary claims relating to quantum. I think you could see sort of problems there. The other quick sort of two issues to mention, obviously reinsurance. That's going to take some time to work itself out, but the way in which policies aggregate domestically in the UK under the policies isn't necessarily how they're going to aggregate at the back end of policies across different jurisdictions, different periods of time, and with different types of clauses in play. So I think there's a few areas of litigation. I think we've got years of this left.
It's going to keep you busy for a while.
Hopefully.
Yeah, I mean, I think in terms of sort of the issues that we're seeing, certainly I've been looking at some of the scenarios for potential claims against brokers, for example. It seems that placement looks really difficult, as you might expect. It's not as if the broker's sitting there saying, I'm going to guarantee to underwrite this policy if it doesn't work. So what you need to look at is the standard kind of negligence tests about, duty, breach and loss. And often they need to sort of show, a policyholder needs to think quite carefully about this, because they need to show that, for example, that they were badly advised in the first place, that there was other cover available and it was reasonable, so it wasn't, for example, hugely high premiums that might have perhaps put the policyholder off from buying it in the first place. And finally, that actually it will actually respond and that there will be cover. So there's so many hurdles on that seems to me, and I think we agree with this, don't we, Dan, that that's quite a tricky area for most parties. It's for an argument to bring. But certainly there's ongoing litigation on some and for various issues, and they'll carry on for a long time. Yeah,
I agree with you, and I'm certainly not encouraging, I don't particularly want to see that sort of wave of claims against brokers personally, but there could be issues at the back end, in relation to claims that are covered. There could be secondary mistakes in relation to aggregation provisions, or the lack of aggregation provisions, or whatever it is. One final thing to mention where we are seeing issues, and I talked about subjective intention of underwriting, in a jovial way earlier, but where we are seeing PI issues again is in relation to MGAs. So MGAs are a function of the market where the underwriting pen essentially gets delegated in accordance with the capacity holders' authority and intention in terms of what they want to write. And we are aware of issues in the sort of MGA space where essentially policies have been written that don't match the underwriter's intention vis-a-vis covering BI events for pandemics and the like.
I mean, certainly it's it's my experience, one of the big problems is having standard wording with one definition of business for insured where there are multiple businesses, because they never expected, for instance, if there was a chain of shops, each one being a separate business, maybe a franchise, that each one would suffer a loss as a business. And then you go to the wording and what you find is, and this hasn't worked through yet, but it's defining one business with one limit of insurance cover. So I don't know whether you've come across that.
There's lots of weird and wonderful sort of permutations that we're seeing along those lines. Certainly, when you've got a business, a generic footprint across the UK,
with a schedule of different types of premises, etc. Yeah.
So that begs the question. Having regard to what's happened to the insurance market, the multiple arbitrations and the future multiple arbitrations, what do you think the availability of cover is going to be like?
Well, I think it's fair to say that we've already seen very quick movement by insurers to try to, sometimes actually mid-term, to try to actually change and to exclude the pandemic going forwards. It definitely, it seems to be that there's a big exclusion for the pandemics and for viruses and for anything of that nature. So wording's being tightened up very, very quickly. But in addition, we're seeing that not only is the cover no longer available, but that the premiums are going up. And I've sort of noticed, certainly, as I said before, with regard to delay in startup cover, whereas there used to be some kind of cover for non-damage extensions, that just seems to have completely fallen by. So definitely cover's going to be a difficult issue going forward.
Well, I mean, I'd echo that in terms of what we're seeing. I mean, if you fast forward into 2022, if we were to have the same events again, I think, I don't think it's controversial to say that there would be very few, if any, BI policies or related event policies or related travel policies that respond to, the same thing that we experienced in 2020. But there is an interesting point about this. I think we talked about it beforehand. Everyone in the audience, would be aware of, Glastonbury not operating, for example, for the last 2 summers because of the pandemic, because of COVID, and the government have only recently stepped in to create a sort of bespoke events reinsurance scheme for that particular industry. And I think it's not difficult to see a world in which, if you can't get cover on the open market, that there's quite a strong case for the insurer for a government-backed reinsurance scheme generally for all businesses, for business interruption, interference in everyday business life. I mean, it has to be right, I think.
And this comes to my way of thinking to a key point, which is the allocation of risk. And before COVID, the allocation of risk was thought always to be the most acceptable way was to pass down the contractual chain, or B, laid off in insurance. And what nobody expected was governments worldwide to do such things as close the country for 3 months. And therefore, what's going to happen and what must happen as a result of all this is really the governments must start laying down some processes and procedures for this sort of event, which allocates the risk. Because as Dan just said, insurance is unlikely to pick up the same sort of cover and risk again. There is no point in an employer passing down the risk to a contractor, a manufacturer, a supplier, if the event happens and you know full well they can't pay. That's a misallocation of liability and risk. And so the real question that arises out of all this, out of all the arbitrations we're working through and everything else, is how do we allocate the risk of an event such as COVID, which is an international affecting event, going forward. And this affects the government more than anything else because it has the largest infrastructure projects. And historically what it's done is allocate the risk down to whoever they are, the main contractor, the big developer, whatever it is. And what's happened is that because a lot of those companies have been shaken, and you can see it happening today, the government is being asked, what it wants to do with those companies going over under. Are they prepared to allow that happen or not? And I'm going to venture to suggest that's poor disaster planning, because all these things were inevitable. The effect on the insurance market is inevitable. What we're seeing by the way working through of these disputes is and was inevitable if you're a disaster planner. And so that begs the question, which we were going to invite your thoughts on in the next few minutes, whether there is an alternative to what is going to happen, which is effectively business for those who do dispute resolution, trying to resolve the problems over the next 2 or 3 years, effectively working through of the ashes of the disaster to try and recover something from those who've been involved. I don't know, Dan or Amanda, you've got any thoughts on that?
Well, I mean, the only thing I'd say is you've only got to look at different areas of life where there are wider public policy issues in play. Flood relief was set up for exactly that reason. The market couldn't sustain the types of losses that it was sustaining in certain parts of the UK because of the climate change. And so it's now a government-backed reinsurance scheme for domestic property insurance.
And what you're finding, isn't it, with the contracts, Amanda, is that you mentioned knee-jerk reaction. Of course, it will come as no surprise to all of you to hear that everybody is amending the contracts to allocate the risk on everyone else. As I say it now, you only have to cough now to have a vitiating factor under a contract. Yeah, and in the long term, commercially, that is not a viable, I think, result.
No, I think that's right. I think the problem is that, as we said, it was something that nobody could foresee. It's something that the contracts weren't intending to cover, because in reality, it's such an unusual event, and it's such a, it's been so disastrous in terms of consequences. But does it seem fair that the parties who are trying to stand there and sort of work out between them, for example, on an infrastructure project, who is going to be able to deal with the risk? Does it seem fair that's being picked up? I think not, because not only that, there's obviously going to be companies that will just go under. And then the whole industry starts getting problems and not being able to move forward, and that can't work. That's obviously not what's intended. So there needs to be some resolution, and I think, you know, as you say, the government needs to step in.
So I notice we're now in the red zone according to our timer. I don't know whether there's any questions people want to ask.
Thank you, Paul. Yes, we've had 4 questions actually come in from the audience during that one. Firstly, should furlough payments be treated as income or savings during the loss assessment process in order to reduce an insurer's indemnity?
Dan, do you want to have the first go?
Shall I try? If you ask an insurance lawyer, they may have a particular view. I mean, look, it goes back to all coverage disputes. You've got to look at the policy wording. But if you look at the definition of income and the definition of savings in most BI wordings, that will give you the answer. So there isn't one uniform argument, but many definitions of income will allow furlough payments, or indeed any third-party benefactor, to be taken out of the income and savings equation when you're trying to calculate quantum.
I'm tempted to say that's an issue for the commercial court, which has a hearing I think in about 3 days' time for directions on the determination of that issue. And I have a clear view about it. And of course, if you want to come and see me, I'll tell you what it is.
Next one. Does the panel see merit in group actions against brokers for negligence in failing to advise when selling policies where the terms of business agreement has a duty to advise?
Okay, well, Dan, I'm going to take this one first because I think I stand in the middle on this. I'm always cautious about group actions because, if I'm blunt, they're often for the benefit of the lawyers and not for the clients. But that being said, you are in a position here where a lot of the businesses have suffered terrible losses over the last year to 18 months and are unable to fund realistically their own actions. And if the only way forward is for a group action, then my view is that's the right thing to do. But the trouble is that the interests of the client is often lost in favour of the interests of, perhaps I'll put it neutrally, the group. What's your view, Dan? I
mean, I touch E&O issues quite regularly against brokers, and I can't see it personally. I mean, I struggle. I think they struggle on liability anyway, unless you've got very specific facts. And another important point to make in that context is that there's, unlike the relationship between policyholders and insurers, where actually there's often mistrust, the relationship between a policyholder and a broker is often based on trust. And leaving aside the legal issues for one moment, or a duty of care in certain circumstances, a lot of brokers out there, you know, they hang their business on building a long-term trusted relationship with their policyholders. And I don't think there's a real appetite out there, is what I'm sensing. And brokers have tried hard to help policyholders through this issue.
We discussed this earlier, Dan, and one of the points you were making is there's a bright line between whether you're covered under the policy and if you are covered, what you're covered for. Whether you're covered seems to me to be being addressed to a certain extent in other arbitrations and in the FCA decision and those sort of decisions. The problem is what you are covered for, unfortunately, is if there's poor wording, that's where it tends to be. And those tend to be not isolated, but very specific to each insured.
Yeah, I suppose I'd only add to that that group actions seem unlikely for the reasons we've discussed before. The fact that it's got to be quite specific in terms of instructions on placement and that sort of thing. It's been quite difficult to get. It's going to be different facts in reality. And as I said, it's got quite a lot of hurdles to cover.
Is there another question?
I think we just quickly, one very quick answer on, is it right for insurers to indemnify only for losses arising during periods of mandatory closure or losses enduring throughout the entire indemnity period?
Well, that depends on the wording, doesn't it? But Dan,
yeah, I mean, it's a very general question. I mean, I'm not sure who asked it, but I mean, it's probably one to discuss afterwards. Maybe we could exchange emails on it.
Yeah, it's just, I'm not sure I can answer that because I've seen policies doing either of those. It all depends. It depends how it's worded. It depends how the loss is worded, the recoverable.
There are wordings out there in the market that respond to government mandatory closures following government action in the context of an emergency.
Yeah, it's the loss. If your wording says that you are indemnified for the loss that flows from an action and there's no cut-off limit, then you are indemnified for the loss not only for the whole period but potentially the time afterwards. It all depends on the wording.
And just to finish that, I think that falls within the species of prevention of access, which is going to be appealed. So.
Yeah, we mustn't get into the law, I understand.
We have just run out of time, I'm afraid. But please join me in thanking you, Paul, Dan and Amanda, for another great session.
Thank you.
Next up, we have a panel from RPC on ethics in arbitration.